Section 125 Clause 1A of CrPC, corresponding to Section 144 Clause 1A of BNSS, makes the husband liable to pay maintenance allowance to his wife who is unable to maintain herself. The explanation attached to the section includes divorced wife in the definition of wife. For minor children, the father is liable to maintain them whether legitimate or illegitimate. However, such a wide application is not given to the term wife, apart from including divorced wife. The normal interpretation of wife here means legal wife. Courts have not always insisted on strict proof of marriage to confer the status of wife on the applicant lady, given the summary nature of the procedure and the legislation's aim to protect women. In some cases, courts have conferred the status of legal wife based on evidence of long cohabitation. However, if the alleged marriage is proved to be void, courts generally refuse to confer the status of legal wife. In proceedings under Section 125 CrPC, corresponding to Section 144 of BNSS, the standard of proof for marriage is lower than in other proceedings. A registered document declaring cohabitation does not automatically confer spousal status. However, if parties have an agreement to marry and actually got married and cohabited for a long period and are socially recognized as a married couple, the wife may be entitled to maintenance. Importantly, the Supreme Court has ruled that a Hindu man with a living spouse who marries another woman is not obligated to provide maintenance to the second wife. A significant development occurred when the Supreme Court ruled on a case involving a Hindu man who, while having a wife and children, concealed his first marriage and wed another woman, according to Hindu rites. The court held that the husband cannot use his own deception to deny maintenance to the second wife. For the purpose of claiming maintenance under Section 125 of CrPC corresponding to Section 144 of BNSS, the second wife should be treated as his legally wedded wife. It's important to note that this principle cannot be applied to the Hindu Succession Act, 1956, as polygamous marriage is prohibited and void under the Hindu Marriage Act. The second wife cannot inherit the husband's assets as a legal heir. The current position appears to be that even though a second marriage during the subsistence of the first marriage is void for inheritance purposes, for the limited purpose of claiming maintenance under Section 125 of CrPC, corresponding to Section 144 of BNSS, the second wife is to be treated as a wife if the second marriage resulted from suppression of the first marriage. If you found this video helpful, please like and share it with others. Subscribe to our channel for more legal insights.